Thank you very much.
Thank you very much, my sister, the Honorable Deputy Chief Justice and Vice President of the Supreme Court. Your Excellency, Professor Kithure Kindiki, Deputy President of the Republic of Kenya, my dear friend and brother, the Honorable Danstan Mulamba, Deputy Chief Justice of the Republic of South Africa, Honorable Gladys Bose-Shole, our Deputy Speaker, representing the Right Honorable Speaker, Dr. Moses Wetangula, Honorable Hilary Sigei, my colleague, Justices of the Supreme Court for France, Madam Harris Wahome. She is one of us. She has practiced law for many, many years. I just want her to greet us. I know she is seeking permission from His Excellency the Deputy, but I am here. This is my time now. I want her to greet us because she is in charge of our key ministry of lands. We live on land. Our courts are in land. And therefore, she knows the reason why I want her to greet us this morning. Welcome.
Friends don't ambush each other. I am thoroughly ambushed by my good friend, the Honorable the Chief Justice and President of the Supreme Court. All protocols observed. My Deputy President is here, and he's officially the one giving the speech. And he asked me which side I am. I think I have been betrayed also. Good morning. I really don't have a speech, and I did not expect to come here, but I want to confirm that I know that my ministry is the largest maybe occupant in terms of the register of cases throughout the country, and we continue seeing very good jurisprudence coming up, and yes, we ought to be maybe doing much better, but all efforts are being done by the government and put in place in terms of funding also, so that we can reduce the cases that are coming even to the judiciary for litigation. That obviously means that we must do automation. We must complete our ADISASA system. The National Land Information and Management System needs to be complete, and that will secure the land tenures, everything, our security of documents. And therefore, Honorable Chief Justice, I also know that this particular, maybe from this wall up there, you have been waiting for titling of the judiciary plot, but not just yourself, actually also the COMESA. We are evaluating, and I know I gave a commitment, and I have been charged by the Deputy President to make sure that we complete that exercise. I want to confirm that we are working on it, and we cannot, of course, be the ones fighting the judiciary in terms, you don't have, in fact, enough space, and therefore we will continue working with you. Thank you for the efforts of the work you do in terms of land cases, but I want to plead that in most cases, if the courts were to call for records of the ministry, the record for land in every other parcel, you will get an answer there, because those that have been alterated, those that have been fraudulently altered, the Chief Land Registrar should give the solution and assist the judiciary coming up with the right answer. Thank you very much.
Thank you. Judges wanted to hear that, especially when we will receive our title for this plot, because they have been asking me and I did not have an answer. Thank you very much. My next special guest with your permission, Your Excellency, our Deputy President, is the Deputy Chief Justice of South Africa, Justice Mlamba. I request you, my brother, I know we ambushed you from a conference you are attending to grace this occasion, and I want you to share a few remarks before I give my speech. Welcome.
Thank you very much, Chief Justice. Your Excellency, Deputy President of the Republic of Kenya, Honorable Chief Justice of the Republic of Kenya, Deputy Chief Justice of the Republic of Kenya, you will excuse me for adopting this line of observing protocols. I'm a peregrinus of this jurisdiction, so I don't want to try and emulate what you are doing in terms of observing the protocol, because I don't want to spoil it. But I want to say, please allow me, Honorable Chief Justice, to ride on all the protocols that have already been observed. It is a distinct honor for me to join you today on this important occasion, marking the annual presentation of the Kenya State of the Judiciary and Administration of Justice report. Please allow me to express my appreciation to you, as well as the appreciation of my leader, Honorable Chief Justice Mandi Samaya, who is your friend, Honorable Chief Justice, to be part of this program. I must also acknowledge the long-standing spirit of collaboration and mutual respect between the South African and Kenyan judiciaries, which has fostered valuable exchanges. I also convey warm greetings from by Chief Justice, as I say, and she will be doing the same thing in a few days' time, next week. So, and she instructed me, not directed me, to take full notes of what you are doing today. It is remarkable that the judiciary of Kenya has firmly demonstrated that it is serious about accountability, especially after its far-reaching constitutional reforms of 2010, which entrenched judicial independence and accountability. The occasion today, therefore, is not merely ceremonial. It is a mechanism for transparency to affirm institutional independence and, in so doing, reinforce public trust in the administration of justice. I therefore commend you, Honorable Chief Justice Martha Koome, that whilst you fiercely promote and defend judicial independence, you have demonstrated your exemplary leadership by embracing judicial reporting in a public, evidence-based and reflective process. Under your leadership, the Kenyan judiciary has made serious strides in being the pallbearer of good practice in this region. I do not want to take much of your time. I just want to say to you, my Honorable Chief Justice said, I must congratulate you and congratulate the judiciary of Kenya for this milestone, and to let you know that we are not far behind. Thank you very much for listening to me.
Thank you so much. Let us appreciate the Deputy Chief Justice of South Africa for gracing this occasion and for those very, very kind words of encouragement. Before I speak, also, I want to recognize the distinguished members of the National Council on the Administration of Justice. Please be upstanding. We recognize you, all the members of NCAJ. Thank you very much for coming. You are a very critical cog in the administration of justice, and we value the support that you give to the judiciary to keep the wheels of justice moving. I also want to recognize in a very, very special way our development partners who are present here with us this morning. Please, if you can be upstanding. I know you will have a chance to speak, but I want our chief guest, before he leaves, to see the people, to thank you most sincerely for honoring us with your presence. I know how tight your program is. His Excellency the President was supposed to be here, but I had him negotiate with you so that you could hold this brief this morning, and we are so, so grateful that you were able to spare time to come and launch for us the Sonja report. I also want to thank the representatives of various arms of government, agencies in the justice sector, our development partners, and stakeholders for joining us for the presentation of the State of the Judiciary and Administration of Justice report for the financial year 2024-2025. Your presence here today reflects a shared national commitment to all of us strengthening the rule of law and advancing the administration of justice. This occasion marks an important moment in our democratic calendar. The Sonja report is not simply a statutory requirement. Like other speakers who have spoken said, it is a constitutional duty anchored in the values of transparency, accountability, and public participation. Through it, the judiciary provides a candid account of the work we have done in the past year, how we have exercised judicial authority, the progress achieved, how we have utilized the resources given to the judiciary. We account for the challenges we have encountered along the way and the reforms that we wish to undertake. This annual report reinforces the judiciary's transparency, accessibility, and accountability as an independent arm of government. It is through such mechanisms that we keep faith with the sovereign will of the Kenyan people, where we remain open to scrutiny and continue to engage Kenyans so that we can build public trust in the administration of justice. The theme of this year's report, enhancing accountability and public trust in the judiciary, speaks to our institutional focus on enhancing public trust, which is the lifeblood of any justice system. Without it, even the most sophisticated courts cannot command confidence, obedience, or legitimacy. For this reason, the judiciary has continued to strengthen the integrity of our systems, deepen internal accountability, to improve performance management, to widen access to justice, and to accelerate implementation of the social transformation through access to justice blueprint. Ladies and gentlemen, this year's Sonja demonstrates the progress we have made in building an accountable, people-centered justice system. Justice belongs to the people. Everybody wants to experience fairness and justice. Therefore, we have undertaken institutional reforms aimed at enhancing the enforcement of ethical standards, protecting the public from misconduct, and ensuring that every judge, judicial officer, and staff members, all of them uphold the highest ideals of professionalism as detailed by the speech by the Honorable Deputy Chief Justice, who is in charge of performance and disciplinary matters, especially for our judicial officers and staff. In advancing public trust, communication and openness remain essential. We strengthened the institutional communication through the establishment of the Judiciary Spokesperson's Office, operationalization of the Judiciary Call Center, and held the inaugural Judiciary Dialogue Day, a milestone participatory platform where we invited citizens in all the court stations. We invited partners and stakeholders where they engaged directly with judges, judicial officers, and staff across the court stations in the country. In addition, our court stations held open days, breaking down barriers between the courts and the communities they serve, and enhancing transparency and accountability at the grassroots levels. Your Excellency, the Deputy President, our guests, access to justice also improved significantly during the last financial year through expansion of the judiciary's physical and digital footprint. We continued to grow judicial presence across the country by operationalizing new courts and sub-registries. These include a new Court of Appeal sub-registry in Garissa, bringing the total number of the Court of Appeal sub-registries to 6. We also operationalized 2 High Court stations in Isiolo and Makandara, and 5 additional High Court sub-registries, ensuring the presence of the High Court in all the 47 counties. Please clap for that. We also operationalized 6 new magistrates' courts, bringing the total number of magistrates' courts to 143 in 133 constituencies. We also handed 3 new small claims courts, increasing the number of small claims courts to 40. We also enhanced the environment and lands court's capacity by establishing a new appeals division in Nairobi. The transition of the Retirement Benefits Appeals Tribunal to the Judiciary raised the number of tribunals under our administration to 27 out of 43 shared services centers for tribunals in Nairobi and Kisumu to enhance access to justice through tribunals and to optimize resources. Your Excellency, beyond establishing new courts, we strengthened the reach of justice through mobile courts, where 59 mobile courts were in operation, which brought services to remote areas. And through these mobile courts, we have registered 7,872 new cases and resolved 6,751. The Judiciary also expanded the court annex mediation, establishing 14 new court annex mediations registries, bringing the total number of court annex mediation registries to 82 across the country. While alternative justice systems, AJS, county action plans were launched in 6 additional counties, bringing the total number of counties where the AJS policy is being implemented to 12 at the end of the financial year. These alternative pathways reduce adversarial litigation. They also restore relationships and reduced pressure on the formal court system. Ladies and gentlemen, efficiency remained a hallmark of our court operations in the last financial year, culminating in a historic case clearance rate of 104%, with 621,000 cases filed as compared to 647,000 in the resolved in the same year. Pending cases reduced by 3%, while backlog defined as cases older than 1 year dropped by an impressive 30%, especially at the High Court and the Magistrates Court. An analysis of case filings during the year revealed an 80% overall decline in criminal cases, and the police are very happy with that, and a 58% increase in civil cases compared to previous year. This increase in civil cases was largely driven by the small claims courts, which recorded a staggering 58% increase in case filings, reflecting its success as a transformative engine of access to justice for individuals and small businesses. Through Mahakama Popote initiative, which Your Excellency is our own innovation, you never left this when you practiced, we were able to redistribute 19,000 cases from high volume courts to stations with lower case loads, resulting in the resolution of 14,000 matters through this initiative, and therefore proving that digital innovation can democratize case management and reduce delays. Digitization has been a major pillar of our reform agenda. We accelerated automation of judicial services through expansion of the case tracking system, adoption of AI-enabled speech-to-text transcription, and enhancement of digital infrastructure to cover 177 court stations and offices nationwide. In addition, we launched the Judiciary mobile application, which has enabled us to improve accessibility of our services by enabling litigants to track their cases, obtain updates, and access information in real time, especially obtaining dates and the mentions of their cases. Your Excellency, ladies and gentlemen, human capital remains the backbone of judicial transformation. The judiciary's workforce, as has been mentioned, stands at 6,979 employees, representing 64% of the approved establishment. The increasing number of stations and expanding jurisdictions demands urgent need for additional staffing to sustain improvements in access to justice and maintain high standards of service delivery. Yesterday, we went to Parliament to listen to the State of the Nation address by His Excellency the President. We had to run away, me and the Deputy Chief Justice, because the members of Parliament are reaching out to us to open a court in their constituencies. And we don't have money to open. So we told them to allocate us money, and then we'll be able to hire staff, because they said they can even build the court for us. However, the achievements in increased case clearance rate have been realized in the context of significant financial constraint, as detailed by the Chief Registrar. These financial constraints continue to affect our infrastructure development, our digitization, because our servers now are growing old, and because of the overload. If there is anything that keeps me up at night, makes me lose sleep, is to imagine that we are going to lose the gains we have made in digitization. We also need to recruit judges, judicial officers, also for the tribunals, and we need to increase our capacity in terms of training and other operational capacities. In addition to launching the Sonja today, we are also launching or unveiling the Social Transformation Through Access to Justice Blueprint Simple Guide, one which is user-friendly, one which can be a simple companion, and one that distills the core ideas, vision, and priorities of STARJ. We want this to be accessible in this format for public consumption. This guide is designed to demystify our judicial reforms agenda. It's also meant to clarify the judicial transformation journey and empower judges and judicial officers, staff and citizens, our partners, our stakeholders and justice actors understand in a meaningful manner what STARJ is all about, and also to participate in our people-centered justice agenda. This simplified guideline reflects our commitment to transparency, civic education, and ensuring that Kenyans not only access justice but also comprehend the systems, the processes, and the values that animate it. By providing clear explanations of the outcomes, strategies, and priorities that we are pursuing, and the role of each actor in strengthening justice delivery, the guide serves as a practical tool for fostering partnership and accountability in this reform journey in Kenya and beyond. In conclusion, Your Excellency, ladies and gentlemen, the Sonja report affirms that the judiciary continues on a steady path of transformation, becoming more efficient, more transparent, more accessible, more responsive to the needs of the people of Kenya. Our progress is the result of dedication of judges, judicial officers, and staff, and the invariable support that we receive of our partners across the government, civil society, professional bodies, and the private sector. I wish to extend my heartfelt appreciation to all of them who have contributed to last financial year's milestone. This is work of our collective efforts that has taken us this far. And with those remarks, it is now my honor and privilege to invite His Excellency the Deputy President of the Republic of Kenya, Professor Kithure Kindiki, to deliver his speech. Thank you, Your Excellency. Thank you.
Asante sana. I would have used that one also. Chana ma protocol mingi. Good morning. My Lady Chief Justice Martha Koome, President of the Supreme Court. It is true that this event was supposed to be graced by His Excellency the President. It is also true that he told you and explained why he could not come. It's also true that through your intervention, he asked me to come and represent him. However, my lady, as good lawyers say when they want to disagree with a judge, with great respect, the president did not negotiate with me. And the president cannot negotiate with me to come here. He directed me and instructed me to come. But as I've said, with deep respect. Now, I'm happy to be here in a very familiar territory. I recognize all the protocols of all the dignitaries present, both from the judiciary, the representatives of the executive, and the representatives of the legislature, the diplomatic people, and the justice sector players. Please, I appreciate each one of you. My Lady Chief Justice, did you notice that the 4 people who are sitting on your left, 2 of them representing the executive, the other 2 representing the 2 houses of parliament, did you notice all the 4 of them are officers of the court? That's how powerful you are. And so, we will behave ourselves accordingly. In fact, we were consulting there when I was talking to my sister there, Minister for Lands. I was asking her on which side, where are we? Are we in court or where? We need to understand how we behave. So, we are glad to be here. The judiciary, not just in Kenya, is a very powerful institution. It helps democracy to operate within the rules and to interpret those rules. But my Lady Chief Justice, great power comes with great responsibility. So it is hoped, even as you launch the report and assess yourself as you deliver services to the people of Kenya, you will also reflect on your responsibility to the people of Kenya, because great power comes with great responsibility. I will not really give a speech. I see some people brought me a speech here. I don't need the speech, because what I want to do today is just to give a few reflections. Because sometimes when you have a moment like this, you don't want to, you just want to be as natural as possible so that you can give your best. So let me just say that this administration came into office at a time when there was an institutional confrontation between the executive and the judiciary. The executive had declined to swear in 6 judges who had been hired to serve in the Court of Appeal. President William Ruto, in his inauguration speech in Kasarani, promised that upon taking oath of office, he will swear those 6 judges, which he did, I think, the following day. From that moment, there has been no doubt that this administration believes, supports, and affirms the place and stature of the judiciary in our democracy. Allow me, my Lady, the Chief Justice, distinguished guests, to also point out 3 other things that this administration has done to demonstrate goodwill and commitment to affirming the place and posture of the judiciary in our democracy. 1, this administration is the administration that has sworn in the highest number of judges of superior courts within 3, and if we extend it, 4 years. Other than in 2003, when we had many judges taking oath of office under the new constitution. There is no other administration which in 3 years the head of state has sworn as many judges of the Supreme Court. And therefore I take pride to be associated with the progress we've made to try and increase the wherewithal of the judiciary to deliver services to the people of Kenya by providing the necessary support and resources to make sure that we increase the number of judicial officers and judges. And so far, 51 judges have been sworn in, judges of the High Court, the Court of Appeal, and also the Environmental and Land and Environment Court. Another 40 are in the process of being recruited, and another 45 will be recruited next year. So we are on a good trajectory. This administration also has facilitated the JSC to recruit 114 magistrates, and another 100 magistrates are currently being recruited, bringing a total to 214 in 3 or 4 years. Secondly, the budget. The 2022 budget for the judiciary was at 21 billion shillings. The current budget, the Chief Justice has confirmed to me, is at 26 billion shillings. It is not enough, but there is modest progress. The Chief Justice has also whispered to me that the judiciary will be presenting a supplementary budget request. The executive, working with Parliament, will support that request. The third thing that this administration has done is to operationalize the Judiciary Fund, which has not been operationalized for 13 years until 2023. It may not be optimal. There are a few things we need to look at in terms of both the amount but also the mechanisms of the judiciary accessing and managing that money independently. And some of the constraints are coming from other independent offices which are also flexing their mandate. And we have undertaken to mediate, oversee a smooth understanding amicably between the judiciary and the other independent offices involved in the disbursement of money to make sure that that fund is used independently, accessed independently, as it is supposed to be by the judiciary. So there is work in progress. And lastly, because I don't want to speak forever, is the judges' retirement law. When I accompanied the president here, some times back, I can't remember what was that. I think it was Supreme Court at 12. When the Supreme Court was entering teenage, I came here accompanying the president. And when we sat in the office of the Chief Justice, there were 4 issues that the judiciary, and I know my Lady Justice Ndungu was there, Justice Philomena Mwilu, Deputy Chief Justice, was there in that meeting, my big brother, Justice Ouko, was in that meeting. There are 4 issues that the judiciary raised that they needed support from the executive to actualize. Some of them have been actualized, and the remaining ones will be actualized because we've discussed and agreed. One of it was the judges' retirement law. And I know the president directed me to fast track the conclusion of that law, which I did. I managed to convene, on behalf of the president, the National Treasury, SRC, the Attorney General. That law was taken to Cabinet. Cabinet approved. We took it to Parliament. That law will be passed in the next few days. That is a demonstration of goodwill, because it is wrong for people who have served the country in the esteemed office of judge to retire into poverty, where they cannot even access medical treatment, where they cannot even move. They are walking in old age after serving so many years as judges. And therefore, these are just some of the pointers to work in progress towards affirming and supporting the judiciary so that they can be, the judiciary can be able to deliver on the mandate that is given to it by the Constitution. And so that is where we are. I have said a few other things remain, and we can discuss that later on, Chief Justice, and they'll be done because that work was delegated to me and I don't fail. I have never failed, I don't fail. The remaining thing, I am glad you called my sister here Alice. She's the one holding us back in one of the issues. It's like you are reading my mind. And when she came here, she spoke very well, of course. But she didn't tell us when you will have the title deed. She said as soon as possible, but that's not what we agreed, my sister Alice. Because again, we negotiated that here with the judiciary, and that meeting was chaired by the President of the Republic. And a decision was made, and I was delegated to follow up as the mtu wa mkono. My sister Alice, you must give the judiciary their title deed before Christmas for this place. And the same way, I am also here because I ought to have been somewhere else, but I was directed to come here. So I'm also cascading my influence and asking you to honor that, to honor that commitment by the President so that we give the judiciary a Christmas of a new judges' retirement law and the title deed to their land here. Having said that, let me commend you, the judiciary through the Chief Justice, on the progress you've made. The automation. I think the judiciary of Kenya has made tremendous strides in automation. And I must thank the development partners who have supported the judiciary of our country to make those strides. I agree with you, Chief Justice, that we should not lose the gains we have made in automation. It has helped in case management and also the speed of the service delivery. When COVID-19 struck our country, the retired Chief Justice David Maraga rules also helped us further by introducing virtual courts and hearings and filing of pleadings and so forth. Let us not, Corona is no longer here, but let us not go back, because what Corona taught us is that some of the things we do really, we can do them differently and get faster results. So I want to commend you on automation. I also want to commend you as the Kenyan judiciary on the strides you've made in the promotion of ADR, AJS, and mediation. Having done that, allow me to conclude my remarks by giving reflections. And my reflections will be not on the administrative and practical and operational issues I've been talking about, but my reflections are jurisprudential, because at the end of the day, the decisions that courts make, especially superior courts, is what now helps us put together the entire service delivery ecosystem. And that's what guides our clarity on the law and the Constitution. Number one, as I said during my remarks during the Supreme Court at 12, I'll be happy as a law student to see greater jurisprudential clarity on the question of the independence of the judiciary. It is it's a very, very highly entrenched principle, and there is no dispute on whether the judiciary is supposed to be independent. What we are looking for is clarity on where that independence meets with interdependence with other arms of government, because at some point, however extreme, however pure that doctrine is, at some point it will intersect with interdependence. That is my understanding of separation of powers, and the old doctrine of Montesquieu, and all the students of constitutional law in the House will agree with me. Because unless you want to persuade me, which you won't, that this independence is limitless, because that again would go against the doctrine of separation of powers, which in its basic form says that every man or woman entrusted with power has the tendency to push that power as far as it can go. So the only remedy to make sure that no arm of government or no person holding public office abuses the power they have is the checks and balances and the intersection between what that arm or that person does with other organs of state. I have submitted before, and I do submit here again, now that I have the chance, that this independence, broad and pure as it may be, must only be restricted to 4 areas. 1, decisional independence, which allows every individual judge and every judicial officer to determine the outcome of a matter before them based on the facts, the law, the evidence. There is no negotiation about decisional independence. That one is pure and it is complete. Similarly, there is my understanding of judicial independence other than decisional independence. It is administrative independence to administer yourselves, the Chief Justice, the Deputy Chief Justice, the Chief Registrar, the presidents of the various courts, and to carry out your administrative you administer the institution without interference. Thirdly, operational independence. to carry out your operations without interference. And finally, financial autonomy, which is what we are discussing here, how we can perfect that. Anything beyond those four legs, decisional independence, financial independence, administrative independence, and operational independence, you must submit to other arms of government and other agencies for a democracy to work. That is my submission, and I could be persuaded otherwise, but not today. The second reflection is on the clarity that we aspire for around our very progressive constitution. My understanding, and here I want to admit I could be wrong, is that the jurisprudence I've seen so far since this very progressive constitution came to place somehow equates the entire constitutional framework and treats it as a set of norms of equal status. So you interpret the Constitution from cover to cover and assume anything and everything provided, all the norms enshrined in that Constitution enjoy equal constitutional status because those are provisions of the Constitution. With tremendous respect, I hold the view that there is a hierarchy of norms in our Constitution. We have a hierarchy of norms in the Constitution. Some constitutional provisions are superior to the others. That is why, for example, by way of example, that is why if you wanted to amend the Constitution, parts of the Constitution can be amended by Parliament, and the matter ends there. But if you touch other norms, you have to go back and conduct a referendum. That already creates a hierarchy of norms in the Constitution. If you touch this one, you go back and do a referendum. The others, you can amend. That is just one example of the hierarchy of constitutional norms. The same document, same constitution, but it creates a staircase of norms. With great respect, I argue that provisions like those in Article 4, Article 5, Article 10, and Article 238 of the Constitution are primordial and entrenched national interest issues which cannot be varied even by the judiciary. If the judiciary attempts to vary those primordial and existential norms, the judiciary runs in confrontation with the people. So the same way some norms are superior is the same way they should be interpreted with care. With care, and I dare say with great care. Because if it is, for example, constitutional amendment, you cannot, for example, amend Article 4, which says Kenya is a multi-party democratic state. If you want to amend that article, you must go to the people for them to decide we are no longer a democracy, we are a dictatorship. So the same way that provision is given that superiority, and there are many others, it's the same way the interpretation of those norms must be very, very carefully handled. And therefore, this hierarchy of norms, we need to see more of it. I brought in Article 238 because Article 238 has bits and pieces. If you read it with Article 10, you'll find bits and pieces of what the framers of the Constitution consider to be the core national interests that must be protected. The internal and external threats to the existence of Kenya are in Article 238. And I'm sorry here, I'm a bit biased because in my journey of service to the nation, I have for 2 years been in charge of the national security of Kenya. And therefore I have a bit of bias there because Article 238 talks on what the national security agencies for both internal security and defense must protect from our sovereignty and the other elements in Article 238. The third and second last reflection is on our Bill of Rights. I want to commend our judiciary for doing a wonderful job in providing a good jurisprudence on our Bill of Rights. Going into the future, I want to respectively suggest that the judiciary should help us to unbundle the Bill of Rights beyond the political and civil rights, because that's where we have concentrated on. I see my Lord here, the Deputy Chief Justice of South Africa. I have a lot of admiration for the legal system and the judiciary of independent South Africa. And again, let me first of all declare a conflict of interest. Part of my education, part of my modest education was acquired in your great country. But having said that, having declared interest, there's nothing wrong with conflict of interest, so long as you declare it, and also assure that it will not interfere with the decisions you make. Now, our country has done so well in providing very robust interpretation of the Bill of Rights, but unfortunately until now, we have concentrated on unbundling civil and political rights, which are the first generation rights. Yet the Constitution of Kenya places at the center of the Bill of Rights socio-economic rights. The reason I mentioned South Africa is because the South African Constitutional Court has given us great jurisprudence on many issues, starting with the right to life issues in the South Africa versus Makwanyane case in 1995, the first landmark decision of that Constitutional Court. But on the question of socio-economic rights, the famous case of South Africa versus Sobromani, the man who had chronic kidney failure and was confronted with a denial for treatment in a South African hospital, yet the Constitution of South Africa, just like the Constitution of Kenya today, had a provision saying very, very clear words, very accurate but very brief and clear words, that no one will be denied emergency medical treatment. And you know, when the lawyers for Mr. Subramani, who was dying out of kidney failure and was denied emergency medical kidney dialysis treatment, went to court. Unfortunately, the South African court found against him. But they gave us very good jurisprudence about socio-economic rights, especially the right to health. Mr. Subramani lost the case. The Constitutional Court gave the decision a day like today. The following day, Subramani died. And many people in South Africa started asking, so what is the business of this Article 27? If the Constitution says you cannot be denied emergency medical treatment, and then the court tells us that this is not enforceable, so what is that article doing in the Constitution? Okay? What is that article doing saying you have a right? So later on, the court redeemed itself, the South African court redeemed itself by clarifying the parameters of enforcing socio-economic rights. Progressive realization, some of the rights have internal qualifiers, it's just access to the right as opposed to absolute right. But at least there was progress on other things around housing, medical, and other socio-economic rights. You have a challenge, the Judiciary of Kenya, to interpret Article 43 of the Constitution. It cannot be muted. You must tell us what those rights in Article 43 mean for Kenyans. And this administration has been very focused. If you look at the manifesto of this administration, very focused on realization not just of civil and political rights, the first generation rights, but helping our country also progressively, subject to available resources, realize the socio-economic rights that are in the Constitution. So, those are my reflections today. I have many others. I have been looking for a chance, which I rarely get, because the kind of things that I do these days are quite opposite of, there is very little reflection in the things that I do. But please, help us. Maybe one last thing. On judicial overreach and the political question doctrine. I'll pose a question. To what extent must courts make determinations that touch on the political doctrine issue? Maybe let me recraft the issue. If an administration in a democracy runs on a program, when it is campaign time, it's called a manifesto. And that administration is voted in by the people elected and sworn in office on the basis of certain priorities. Housing, health, we will do this in health, we'll do this in housing, and the people says, go ahead and do it. Okay? Because there is another group looking for leadership saying, we don't like this, we are in the opposite side, we don't like this program on housing, we don't like this one on health, we don't like the other one. So when the people decides that we want these things done, it is true courts must always help us at the end of the day, in the long term, to ensure that whatever is being run, if it is a program on housing, on health, and so forth, it is done in accordance with the Constitution and the law. But I'm just wondering why, again, in the question of balance, why is it that as an individual litigant, individual citizen, who is aggrieved by the implementation of a program that has been passed through by the people in a popular manner, and in fact, that administration is now being judged on the basis of those commitments, why should my right as an individual and commercial rights, let me put it that way, maybe commercial rights, maybe I'm not happy with a decision which was made on who implements, who implements that program. Why should my right as an individual frustrate the implementation of a program which has been approved by the people in a democratic place, especially on an interim basis? Why should my right stop the implementation of a healthcare system, I'm just asking hypothetically, or a housing or whatever other issue program, it can be on education, etc., and arrest the progress of 55 million Kenyans? The question I have, why can't I litigate my right as the rest of the country implements a legitimate program that has been validated by the people, in the event that in the final analysis my right has been violated? I'm sure 55 million people can compensate my damage as one person, but the one person cannot compensate damage caused on 55 million people whose rights to the services delivered by this program have been frustrated by interim orders that have taken 3 years to discharge. I submit. Thank you very much and have a good morning. And I'm sorry for if there is any executive overreach.
Thank you very much. Thank you very much, Your Excellency. With your permission, we may take our seats for a few minutes. With your permission, Your Excellency, we may take our seats. And may I now invite your attention to the screens for a special video presentation, after which I will request Her Ladyship, the Chief Justice, to present the SOJA report formally to His Excellency and to the Houses of Parliament. Technical team, are you ready? In the interest of time, Your Excellency, allow
This
me.
is a this
very much for that. May I invite a round of applause, please, for the work that you have all done this year in making this report a reality. Honorable Chief Justice, may I welcome you to the stage, with the Honorable Deputy Chief Justice as well. May I also welcome the Deputy Speaker of the National Assembly and the representative of the Senate, Honorable Senator Hilary Sigay. And with your permission, Your Excellency, may I welcome you to the stage for the formal presentation. Let's have the reports. May I also welcome Honorable Aden Daud to join on behalf of JLAC of the National Assembly. I think that James, to be able to formally hand over, we can allow the Honorable Chief Justice to hand over the report to His Excellency. Honorable Chief Justice, you may now hand over the report to His Excellency, signaling the fulfillment of the dictates of the Constitution. We will also have a moment of celebration. That really is a testament of the fulfillment of the law and the Constitution that requires full accountability to the Kenyan people. Thank you very much. Honorable Chief Justice, allow me, Your Excellency, to welcome the leadership of the Judiciary leadership team to join you on stage as we celebrate this launch. And the Judicial Service Commission. We have Honorable Senator Dan Manzo as well. Please join on stage. And our two special guests, Honorable Alice Wahome and the Honorable Deputy Chief Justice of South Africa, so that we can have a complete indication that is the leadership of our country, the leadership of the judiciary, the leadership of Parliament together during this momentous launch of the State of the Judiciary and the Administration of Justice report. We will have that photo. And thereafter, I will request that we are joined by the President of the Law Society and all the speakers on the program today for a picture. The PS Correctional Services. We can have a photo, a complete photo. Zakim will help us organize the photo. I will thereafter invite it is important because we will hold this photo as a continuing relic of our collaboration and cooperative governance as dictated by the Constitution. Band, please continue. After this photo, I will welcome all the judges to also join the photo. All our judges present. The State of the Judiciary report could not be without your phenomenal contribution and indeed the tireless efforts to enhance case clearance to the historic 104%. It has been because of your tireless efforts, because of your innovation, and because of your continued commitment to access to justice that this day and this report is as monumental as it is. I can request our speakers to take their seats as we allow the judges to join the photos so that we only have the leadership of Parliament, the leadership of the Judiciary, His Excellency, and the honorable judges. Indeed, that is the sound of patriotism, and this is the face of access to justice in Kenya. On the screen, you will have a QR code. The protocol team will also distribute the state of the judiciary at a glance so that you can download the report and read it at your leisure. We have summarized the report for you in an abridged version report, and we are happy to continue with this conversation. Thank you very much, Your Excellency. With your permission, I will welcome the Honorable Chief Justice to escort Your Excellency to leave at your leisure, and we will continue here for the rest of the program. May I request that we remain here to be able to continue and complete the rest of the program. As His Excellency departs, we are grateful. We thank Your Excellency. We thank the leadership of Parliament. We thank our partners for joining us and continuing to support the judiciary in the execution of our mandate in fulfillment of the constitutional dictates of access to justice. Band, you can give us some entertainment.